Okay, gentlemen, we're back after you've had a chance to talk a little bit on that family veterinary case with Catch One LLC. Mr. Carpenter and Mr. Sifford, where are we at?
Go ahead, Jason.
Your Honor, we've decided the best way to move forward for everyone's time, including the court, we would argue on our motion and defense that we raised of the force majeure clause within the lease, and leave it up to Your Honor to decide what amount, if any, would be discounted off their ledger. And at that point, we would allow a money judgment and a possession judgment to enter for that amount. Okay. Do you anticipate testimony in the argument, or just making the oral argument on the force majeure? Ron and I did not go over that. If we did, it would be very quick. Okay, that's fine. And I guess I would also like to get Ron's input, because I don't want to speak for him on that. Sure.
Yeah, I think I might want to have Jason Sutphin testify very briefly on the issue.
Okay. All right, that's fine. And then if you could give me the numbers that you're alleging from your perspective, Mr. Carpenter, your client's perspective, and then Mr. Sifford, when it's your opportunity to argue, I'd like to hear what what you think the abatement issue is, or the amount. Okay?
Yes, Your Honor.
And I know that it's your motion, Mr. Sifford. I don't know if that means you want to go first or how you want to go forward.
No, we could. I think Your Honor's suggestion that if Attorney Carpenter goes first, that might save a little time, because then the court will know what the starting number is.
That's fine. Sure. Okay. All right, Mr. Carpenter, you want to start by making any statement, or do you want to just call your witness?
I'd like to say a few things first. That's
fine.
There is a force majeure clause in the lease. It's paragraph 29. As you'll recall, restaurants in Michigan were basically shut down from about mid-March until I think about the end of May. So for a 2.5 month period. And my client, Family Veterinary Real Estate, actually agreed that Catch One would not owe any rent for that 2.5 month period. So we agreed that because they were completely shut down, the force majeure clause allowed, we agreed that they wouldn't have to pay any rent for that 2.5 month period. But then they were allowed to reopen in, I think, around late May. And as Mr. Sutphin will tell you, he works right next door to the restaurant, the property adjacent to the restaurant. So he sees what is happening at the restaurant on a pretty much daily basis. And he'll tell you that they've been doing a pretty robust business since early summer. They have several outdoor tables, and they've also been serving people indoors. And he's seen, he'll tell you that he's seen days when it seemed to be pretty much filled up, the restaurant. It's a small diner type restaurant. The other thing I want to say is that in early June, Mr. Sutphin and Mr. Chudik sat down, just the two of them, and they agreed on basically a settlement that provided, that gave Catch One a payment plan to catch up on rent. And they put that in writing, and it's just a half-page handwritten thing. And it said nothing about force majeure or reduced rent. And this is the first trial I've ever done on Zoom, so I'm not quite sure how to get a document to you, but can I email you a document?
Yep, that's fine. It
Okay,
would
I
go
will,
to, for some reason, there's a feedback. Amanda, Amanda dot Dubay, Dubay, at kentcountymI.gov, Gov. That's my clerk, and she'll get it right here in the courtroom.
okay. Another point I want to make is the last time that Catch One was completely caught up on rent was July of 2019, which is well over a year ago. And obviously that date predated by many months the COVID-19 situation. And I guess the last thing I want to say is I think the parties agree that assuming no force majeure rent reduction, that Catch One currently owes Family Veterinary $16,022.22 as of today.
Okay,
That's it.
all right, I appreciate it. Are you going to have your representative speak, or do you want to wait until you hear them?
I could go either way on that.
It's not needed, but what was his name again?
Jason Sutphen,
Yeah, how do you spell it?
Sutphen.
Okay, I'm looking at him now. Okay.
I guess we could let Jason.
Yeah, I would just indicate, Mr. Sutphen, you don't disagree with anything your attorney said. He's just tried to give a very brief synopsis. If there's something more you want to add later, you can, but we'll just go forward from there if that works. All right, Mr. Siffert, why don't you state what you want to say and then anything Mr. Chudik might wants to say.
Yes, thank you, Your Honor. So addressing some things first, because I think it'll make it easier for the court. There was a, in a sense, settlement agreement signed by Mr. Chudik and Mr. Sculpin back on June 4th. I do agree with Attorney Carpenter. I have no reason to dispute that, and I do have a copy of it in front of me.
Okay.
Now, as far as that moving forward, in my estimation, the way that agreement worked was for past due rents at that time. There was, in Attorney Carpenter can correct me if I'm wrong, but it's my understanding that the past due rent was $12,827. And under the terms of the agreement, Mr. Chudik had to make a initial $5,000 payment, which he did, and then those periodic $1,500 payments thereafter. Now, that entire sum was paid up, and that was to avoid a court date in late July, because at that time, those were the past due rents owed. And that's what would have been presented to the court in July. But due to COVID, we were adjourned a few times, Your Honor. So in my estimation, moving from July 1 up until today, which they're including July 1st all the way through October 1st in the rents owed, that is still up for play as far as the force majeure goes. Now, I understand that Attorney Carpenter is making an argument that he hasn't been timely on rent since July of last year. Well, that's not really relevant to an argument that is, in essence, narrowed down to July of 20 to October of 2020. And if my client is to testify, you'll hear from him that his business has been decimated. Regardless of what they see going on a daily basis from the veterinary clinic, he has followed all executive orders to the T. He's not one of these businesses that is allowing more people than what is limited under the executive orders. His revenue, even since the Michigan Supreme Court handed down the recent opinion, that doesn't change people's minds. We still have an unprecedented pandemic going on. People are afraid to go out. People don't get takeout. People don't go out to restaurants with their families anymore. His revenue, not by his own choosing, not by his own doing, or his failure to mitigate anything, it is strictly due to the executive orders and the pandemic. His revenues are down at least 50%. He doesn't, again, it's not by his own actions. He doesn't have the ability to meet the demands that he used to as far as rent goes. And I think the force majeure is quite clear, that any restrictive governmental laws or regulations or other reasons of a like nature, not the fault of the party, that causes a delay in performing their obligations under the lease, is something that this court can enforce. They're both contractually bound to that. And on top of that, when we're in summary proceedings, the court has equitable powers. And I think that even the force majeure clause aside, the court can reach into its equitable powers under the summary proceedings and give my client some equity that's due, because these actions of the government and the pandemic are putting him in dire straits. He can't have the same amount of business he used to, and it's out of his hands. And again, it's not by virtue of him failing to mitigate this or take other action. He is squarely at the will of a virus that's wreaking havoc on businesses all over the world. And we would ask that Your Honor take the force majeure clause into play when we're talking about what's due and owing, and to also consider using the court's equitable powers to give my client what's fair and equitable under the circumstances. This is his livelihood. If he's forced out of this business, he has no idea what he's going to do, Your Honor. And I'm just asking to give him a fighting chance. Thank you.
All right. Do you want to say anything, Mr. Chudik?
Yeah, I do. You know, it's not that we're trying not to pay the rents or pay the amounts. I've sat down with them and we made that agreement in June, and I came up with the money and paid for it. You know, this pandemic has raised havoc, especially with the restaurant industry. We're still under the executive orders of 50% occupancy, whether it be outside or inside. That's not changing because now it's being enforced by the health department with fines and so forth. I don't see it ending anytime soon. It has cut our revenues. This time last year, we did over 400,000 in sales. In 2019, which we were well on our way in January and February to having record sales and record months. And now we're at $220,000. You know, so there's no, you know, if you see on TV people talking about restaurants, there's no way to plan for that when it happens in 3 days. Okay, it took us a long time to change our business that drastically, that quickly. And, you know, I'm at the will. I mean, I don't want to owe them any money. I would like to pay them as much as I possibly can. But you know, we don't, you know, everybody says it's 50%. Well, it's not 50% that we're losing because we don't have the traffic that we had before COVID. People are not as you know, free to come out now. They're just not. And yeah, we do have some busy days. Saturdays and Sundays are our busy days, but we also have, you know, our patios cut in half. We have half the tables that we would normally have. And we only have 4 tables and a few seats inside with the regulations. because we can't have people sitting at the bar area because they have to be 6 to 8 feet apart. So we're under a lot of restrictions, and we're working with it and learning and changing our business as necessary to try to come out of this. So thank you.
Okay, appreciate that. Okay, back to you, Mr. Carpenter. Is there any follow-up that you want to say after hearing from Mr. Sifford and Mr. Chudik?
Yes, I have 3 or 4 points I'd like to make. 1 or 2 of them are reiterations, I guess, of something I've already said. But again, the last time Catch One was current on rent was July of 2019, long before the COVID-19 situation. As far as the early June 2020 settlement agreement that Catch One and Family Veterinary worked out, Catch One did not comply with that payment plan. Maybe for a short time, but fairly quickly they stopped complying with that payment plan. So I don't want you to think that they did strictly comply with that. They didn't even come close to strictly complying with it. Again, as Mr. Sutphin is prepared to testify that he's seen a lot of business at the restaurant since early summer, and he suspects that the restaurant has not been complying with the government restrictions in terms of number of customers. He thinks they've been doing a good business all summer and fall. My last point is, if the reason that their business is down, assuming it is down, is because people are afraid of the virus as opposed to government restrictions, then the force majeure clause does not come into play, because the force majeure clause only talks about inability to do things like pay rent because of government action. So if it's not the government regulations that is keeping their business down, it's the customer's fear of the virus, and that's a very different story. And I don't see why the cost of that should fall on the landlord as opposed to the tenant. That's not what the force majeure clause says. I guess that's all I have.
Okay. If I could just ask a question, we haven't seen that document, Mr. Carpenter. I don't know if you emailed that.
I sent you the one document. It's called a timeline.
Okay. And did you send it to the
figure-
Amanda Dubé at kentcountymi.gov?
Yes, let me confirm that. But
The last name is D as in David, D as in David, U-B-A-Y. We just haven't received anything, so I wanted to verify that.
yeah, Amanda Duvay at Kent County.
No, dot, Amanda dot,
Right.
D, U, B as in boy, A-Y,
Oh,
Dubé.
it's B, not V?
Yeah, it's B as in boy, D
I'm
as
sorry.
in dog.
Okay, that's the problem.
U, B as in boy, A-Y, Dubé.
Okay, that's
Okay,
the problem.
just resend it, just resend it. And then let me ask you while you're doing that, and Mr. Sifford, maybe I can just ask you, although Mr. Carpenter would be fine too, but what is the monthly rent right now?
I can answer that, and Mr. Carpenter can correct me. I believe it's $32.50 a month.
Correct.
Okay, okay. If you ask the normal person on the street what force majeure would be, it'd be a good Jeopardy question, because most people wouldn't know what it is or what it means. And obviously, the parties put it in the lease, whether they thought much about it or not, and we're focused on the governmental regulations, but when you look at the force majeure provisions, I mean, it talks about a lot of different things like war or strikes, lockouts, labor troubles, even inability to procure materials, et cetera, civil disturbances, riots, picketing, demonstrations, et cetera. I think that when you're looking at this, and I'll get into telling you what I'm going to do, but before I do that, I do want to see that document that you agreed on in July or June, early June. But was there anything else, Mr. Stupkin? We didn't give you we did give you a chance, but do you want to add anything? Is there anything you've been thinking about that you wish you could say?
We can't hear you, Jason.
You gotta unmute yourself.
Still can't hear you.
Yeah. Join audio. There should be something that says join audio or unmute yourself. A mute button with a microphone and a line through it. Can't see it, can't find it. Yeah, we can't hear anything you're saying. We can tell you're talking, but we can't hear a thing. All right, hang on a second. Mr. Carpenter, what's his telephone number? Never mind.
I will find that.
Hold on. Are you saying he's connected? Mr. Stuffin, there's a button if you look on your screen at the lower end of it, and it should say join audio, or it should say unmute or mute, a mute button. And you have to click on it. Not working, not happening. What's that number, Mr. Carpenter?
Let me find it here. 616-894-6999.
We're trying to call you right now, Mr. Stuffin, on the other phone.
Nope, I can hear you now.
Well, I don't know what the connection problem is, but there should be something on your computer that lets you connect with us, but we weren't finding it.
Yep, I definitely apologize for that. I certainly see the mute button. It shows that I'm unmuted, but for some reason it is not working, so I do apologize.
No, it happens, and it's
No,
not
it's
causing
working.
a backlog. Yeah. So I had asked, like, if there's anything you wanted to add. You've been listening to everybody. What is your thoughts?
Yes, thank you much for giving me the time. I just wanted to echo, let me put my other, we got a noise this year. Yeah, I'm sorry. I just wanted to echo my attorney's comments in terms of the agreement that we entered to in June. I kind of heeded the court's call to action and tried to settle this case. And I met with Mr. Chubik, and we did come up with an agreement where he could pay us for the back rent, which was the amount of $12,827. The agreement was for Mr. Chubik to pay us $5,000 once, and then $1,500 every Monday. That agreement should have ended in roughly 6 weeks, and he did not comply with that agreement.
Right.
So I just wanted to make a point that, I heard the call to action. We tried to settle this thing, came up with a very reasonable plan for Mr. Chubik to get current.
Right.
And he avoided the agreement.
Well, in the end, the $12,827 was paid, just not timely. Fair?
Fair.
Yeah. It just wasn't followed with the agreement that you guys made to
Your
the
Honor.
letter. Yeah.
Your Honor.
Dating all the way back to the previous year, yeah.
Yeah. Okay. All right. Anything else that you wanted to say, Mr. Stuffin?
I think the only thing I'd want to say that we've been very reasonable with Mr. Chubik through his lease. He's on year 3 of his lease. And we have had numerous payment problems with Mr. Chubik. We certainly understood the COVID pandemic and the situation that he was in, and offered him a concession, and we were happy to do that.
Uh-huh.
We gave him April and May rent free and 50% off of March rent.
Right.
Because we understood the situation, and wanted to work with Mr. Chubik, which is also why we signed up that agreement with Mr. Chubik.
Right.
He failed to comply, and we've been try to comply with him. And
What is that family veterinary real estate? What is it right next door to Dan's Diner? What is it?
it's Family Farms Veterinary Hospital. We operate a veterinary hospital here, and we own the property adjacent to us, which is Dan's Diner.
So it's just that property that's owned by Family Veterinary?
Yeah, so we own the veterinary hospital property and the property adjacent to us, which Dan's Diner sits on.
Right, okay. Is that the only other commercial business there, is Dan's Diner and your vet place?
Yeah, next to us is a hardware store and a bank, and
But those aren't part of your real estate?
that's correct.
I gotcha.
Yep.
And realistically speaking, the veterinary business has been decreased since the COVID as well, fair enough?
Fair enough, yeah, absolutely. I mean, we've had to pivot quite a bit.
Yeah,
In terms of how we operated, just like restaurants had to pivot by doing, takeout and outdoor seating. We're doing all curbside appointments.
yep,
So our clients haven't been able to come in our building since April, so
right.
it's been tough, but we've been fighting through.
Right, okay. All right, I'm going to disconnect the phone just so that you can still hear us, of course, with us not on the phone. But if there's any need for you to speak, you're going to have to give me the hands up sign so I can see you. All right, thank you, Mr. Stuffin. Okay, thank you. All right, Mr. Chudik, you wanted to say something.
Well, yeah, when I sat down with Jason to make that agreement to get him paid up, we said that, because we had just been able to open for the first time on the 16th of June. I said, I don't know how this is going to work. I said, I've never had an executive order that I couldn't fill my restaurant with people. And, it was just that, and it did take a little bit of time to pay that extra than I thought, but we did get it paid, and I think that, that we're working here on a 3-year agreement or 4-year agreement. We've been here going on 3 years now. And, people like what we're doing here. It's just, there's other issues too that needed to be, that arose from this and started with this, meaning that the building hasn't been taken care of. The roof still leaks in the dining room, the roof still leaks in the kitchen. So there's other issues than just, that the reason why we held out on some issues and so forth. So, and that's what really started this whole litigation when I met with Scott Kuiper or Scott with the time, was the issues with the building hadn't been fixed. When I sat down with Jason, he said he was going to get them fixed. They're still not fixed. Still leaks in my kitchen, still leaks in the dining room. The facade of the building's falling off and is rotted. They won't fix it. So we've gone around and around with this, and it's not just us.
Okay. All right, I appreciate that. Is there anything follow-up that you wanted to say at all, Mr. Siffert?
No, Your Honor, just that, and I think Your Honor did a nice job of reading through the force majeure, that it's not strictly limited to restrictive governmental laws or regulations. Although we had those in play, that's strictly within that definition. It does say, or other reasons of a like nature. Now, it's very expansive, and I just need to address the argument that it wouldn't cover people's fears of COVID and not going out. I do not agree with that assessment. I think that would fall squarely within the other reasons of a like nature. And it is true that people don't go out. I mean, people are not going out. I see it every day out the window of my office. We're downtown, and I can tell you this is something that's completely out of the ordinary. And his business has taken a hit. I think as Mr. Chudik said, they're down to close to 50% from what they were last year. So thank you, Your Honor.
Okay, anything final then, Mr. Carpenter, as the plaintiff in the case?
Yeah, I want to make sure you have the two things I've been trying to email to you. The timeline and the June 4th agreement. I'm not sure.
I don't know if there's a problem with the email again, but she's indicated that she has not get it. She has indicated that she has not received it yet. Although I think I have enough information from what you've told me to go forward.
Okay. Another point I want to make here is that Catch One has not made a payment in any amount since August 11th of this year, which was over 3 months ago. It looks like Mr. Sutphin is signaling that he would like to talk some more. So.
Okay, hold on. Mr. Siffert, you're gonna have to give me that number, or Mr. Carpenter, you're gonna have to give me that number again.
Okay, I gotta find it here.
I should have written it down. That's the problem with Zoom too. You're not always looking at the screen because you're doing something else, taking notes, and I didn't see him doing that. I did get the documents.
Good.
I did get that. I got the agreement.
Oh, okay. His number is 616-894-6999.
Hello, I'm sorry.
Yeah, okay, what were you gonna say, Mr. Stuffin?
Yeah, no, thank you for the time. I wanted to just react to Dan's comments on other ongoing issues about the buildings falling apart and roofing issues. We have addressed those. I've had a roofing company, professional roofing company, come to Dan's Diner 3 times now over the course of the past 2.5 months. We also replaced the roof back in 2018 at a cost of $15,000. So we have definitely addressed those as he's brought them up to me.
Uh-huh.
So those have not been ignored, and I wanted to make sure the court knew about that.
All right, appreciate that. All right, thank you. Uh-huh, thank you. Okay, and I get, Mr. Chudik, that you have your position as it relates to how the property is or what ongoing issues, you got to address that with your landlord, no question about it. Any final statement that you wanted to make in the end, Mr. Carpenter, then? You made your points. I got the paperwork.
No, I think I'm all set. Thanks.
All right, then, gentlemen, let me just say this. I'm not here to solve all the problems, but I am going to resolve this matter, and I'm not asking for anybody to agree with me. I understand totally that you all have your own opinions, as strong as they may be, and accurate. I'm not here to try to change your minds. I'm trying to give you some legal review of an issue that has not been resolved. And we're really focusing in on this provision of the force majeure, which I wasn't trying to be funny when I said if you ask people on the street what that is, they wouldn't know it. I wasn't trying to be funny to say if it's on Jeopardy, some of the smartest people would get it wrong, because it's not something you see that often. It is really meant for unforeseeable circumstances. And to have Mr. Siffert and Mr. Chudik, describe to the rest of us what this pandemic has been like, well, I mean, seriously, we could go on forever. Never in our lifetimes, I'm probably older than all of you, never in our lifetimes have we ever even thought that something like this pandemic could occur. Everything, and you could pick any occupation. Yeah, restaurants are being hit. Nail salons are being hit. Bowling alleys are being hit. I mean, you could name a ton. We could keep talking forever about different commercial businesses that have been so severely impacted. And you could pick up the New York Post and read every day about what's happening, the percentages of businesses that are having to not just stop, but close, like completely closed, like never to be opened again. And there are businesses like Dan's Diner that have had to make that gut-wrenching decision that they cannot go on. They simply can't go on. When you talked about, Mr. Chudik, the sales from 2019 versus the sales from 2020, even though we're not done with 2020, I was honestly surprised that it was even 50%, because I thought you were going to give numbers that were so drastically different. And yes, the government did step in and make decisions. And I don't want to get into the whole political thing here, but, you know, I do believe that those decisions made by our health departments and by our governments were meant to be life-saving. And while Mr. Siffert says you should see it downtown and hardly anybody's there, I mean, I work in a building where we just recently opened to the public and we're having very few people come in. We're doing almost everything by Zoom. So what's happening to you, Mr. Chudik, is unique in the sense that you run a restaurant. It's not unique in every aspect that it's affecting every other business, like the veterinary's office in the hospital next door, or like the hair salon that's down the street, or the bowling alley, or yada, yada, going on and on and on. Now, I feel like what I've been asked is to look at the language of the contract and apply what would be what the parties believed it would be. And honestly, if you went pre-COVID, and some of this is clearly COVID related when you talk about the force majeure, but this isn't just about COVID. Really, it's not. Did we lose Mr. Chudik?
I'm listening, Your Honor.
Oh, okay, good. I just didn't want to, I looked up and your face was gone and I wanted to make sure you're listening. Okay, so anyways, it's not just about COVID. COVID has caused more problems than anyone could ever imagine. And I'm not disputing that in any way. But when you read the language of the contract, I don't think what it means is, I don't think that it means that the tenant is excused from ever paying rent. I get that there have been governmental regulations that stopped Mr. Chudik from doing his business. And I do think that the time period that was given for no rent at all did meet with the language of the contract. While family veterinary real estate might believe that they did a good thing by giving Mr. Chudik a complete rent abatement for those 2.5 months, they never in a million years would have thought that that would ever happen. But because of the circumstances with the governmental regulations and the prevention of people from coming out, whether it be a fear factor or anything else, obviously affected every aspect of our life, every aspect of our home life too, because you can't do things at your house that you always did. The neighbor kids don't come running through. You don't have people over, on and on and on with every example there. But when I'm looking at it, to say that the tenant, Dan's Diner, would get a reprieve, you keep there, you keep the business as much as you can, but you don't pay rent, it almost begs the question as to when would it be ever over, where it would stop a party from fulfilling the contract. At what point would you say, is it only when the government intervenes and says you can't do this or can't do this? And my position is that the veterinary hospital is going through a scenario where they are affected in a different way, but their sales are down, their business is down, and you go right down, even with the Fifth Third Bank or whatever, the Ace Hardware or whatever the stores are. I mean, go right down the line, and you'll see maybe the grocery stores are the only ones that don't feel like they're hit as much because we all need groceries. But I bet you they'd even say, then you'd look at some businesses where they've thrived. Their numbers have increased dual or triple because of COVID. It's completely changed, and they're busier than they were before. And I'm not going to get into some kind of analysis of the whole COVID pandemic, but recognizing, yeah, I get that it's affected your business hugely, Mr. Chudik, as it's affected everybody in a different way, and I get that. Because if you had a bowling alley, if you had a diner, it's affecting you more than some other people. But if you had this other business, it's the opposite effect because you're getting more business. My only point in bringing it up is, yes, I think there's an abatement that is reasonable. And I think that the Family Veterinary Hospital tried to work with you on that. The only reason I say I don't think it's all about COVID is because it's not, when you're talking about, is it about money? Is it just about money? Because I did an escrow order a long time ago that's never been followed. So if the dispute is really about the HVAC, or if the dispute is really about the roof, it's not really about the money. But here, it really is about the money, or the lack of money. Because like you said, Mr. Chudik, if you wish things would be back the way they were, we all do. We pray about it. We wish it would happen, but we don't know how long. And I think when you try to look at that force majeure provision in the lease and try to say this means you don't pay rent for this period of time, this period of time, this period of time, I think it defeats the very purpose of what was meant. And there was a serious abatement of 2.5 months. And all I'm going to do in making my decision, and perhaps part of what Mr. Siffert said about the equitable jurisdiction of the district court and the powers that we do have, there's just over $16,000 that the plaintiff is saying you're behind. What I did was I subtracted another month's pay of $3,250, which I thought is reasonable in light of everything. It's not that I'm going back and trying to compare the sales and when do they get up to where they should be, because that may never, ever happen. But that they're over the course of the time to October, and I'm going to the end of October, that it's reasonable to give a percentage. We have a rental eviction diversion program that the state set up, and they're asking the landlords to give a percentage of abatement just to be part of the eviction diversion program. I didn't do a mathematical percentage. I just took a 1 month period of $3,250. And I get that Mr. Stuffin and his business partners or whoever owns Family Veterinary may not agree with it. But my decision is a monetary judgment in the amount of $12,772.22. And all I did was take $3,250 off the $16,000 figure. Court costs can be added to that. It's called a money and a possession judgment. That's the way it was filed, Mr. Carpenter, on behalf of your client. You can prepare the order, and that's my decision. So in essence, the force majeure is applicable and was applied to those 2.5 months earlier on in the year. I've allowed for it to be a percentage of each of the next months. And I'm not going to review it every 4 months and say, does it apply? we're back into it, whether you keep the business or you don't, Mr. Chudik. Okay, now questions that you have at all. Mr. Carpenter?
I don't believe I have any questions, Your Honor.
Mr. Sifford, any questions that you have?
No, Your Honor, you made your ruling very clear.
I expect that Mr. Carpenter will just prepare the order under the 7 days, send it to the court, have a chance for you to look at it, Mr. Sifford, if there's any questions or concerns. I didn't put it formally in the aspect of your motion, but it's pretty clear what the decision of the court is. Hopefully you guys can just go from there.
Yes,
Any
Your Honor.
other questions anybody has?
No, Your Honor.
Nope.
All right, I appreciate your courtesy, and as I said from the very onset, I recognize that not everybody's going to agree with my decision or feel that it's appropriate or fair. Some might not. That's not my reason for ruling the way I do. I try to listen to everything presented and apply the analysis to the legal aspect of that provision in the lease, which, when you think about it, in all due respect, probably nobody really read that very much at the very beginning of the lease. Like when you're renting your car at the place on vacation and you don't sit there and read 3 pages. All you want is your car to drive to the beach. And that's really, I think, not that it was wrong. I don't think it's wrong to be in there. But like I said, we don't see that hardly ever. And I think it is meant to be protective both ways, but not to be a free pass. So hopefully you understand my decision in my ruling. Okay, gentlemen, I do appreciate the fact that you took a fair amount of time at the onset to talk it over. And I get that you've been talking it over the time, like Mr. Suffert and Mr. Chudik sitting at the picnic table writing up that agreement. I mean, I get that there's been effort made. I don't know what the future holds, and I don't know how it'll pan out, but I've made my decision. All right, thank you, everybody. Appreciate your courtesies.
Thank you.
Your Honor.